students and teachers, welcome to the 4Bs. For some people, it is spring break, which might explain, the mood around here. And you'll also, I'll save that for maybe at the end. I have an observation I've made. Today, we're going to be talking about habeas corpus, its evolution and possible limits on this. For those of you in We the People, it comes from Unit 1, Question 2. And so I want to start off, with you, Mr. Kavanaugh. We're Mr. Kavanaugh. Okay, we switched. With you, Mr. Kavanaugh, and because again, in fact, my son, I was talking to my son, who's kind of our, editor and YouTube guy, and he says, Mr. Kavanaugh, you're very good at kind of breaking things down for students and giving them a lot of clarity after I've done a lot of confusion there. So explain your understanding of what habeas corpus is. And I'm wondering that, do you think that habeas corpus is in many ways the best expression? All right, and we'll call it the suspension clause, because that's what I found out, kind of how lawyers describe it there. But do you think that clause is maybe the best expression of the individual rights versus collective security, quotient in our system?
I guess I'm not sure what you mean by that in terms of, are we considering an individual right? Is that, or is it a group right? Is that what you're asking?
Well, and again, I want to get into that. Let's assume for a moment that it is a right.
Oh, yeah.
Okay. And well, first of all, why don't you explain what it means to you? Do you not see it as a right?
Sure. Oh, yes, absolutely. It means to have the body, or you have the body, right? I think really it's, I know students, We the People students, especially Unit 5 kids, will talk about amendments, 4 through 8 in terms of procedural due process. And I don't think you can talk about due process without talking about the habeas clause or the suspension clause in Article 1, Section 9, right? Article 1, Section 9. I don't think you can talk about due process without that, because that really is kind of at the heart of due process, that you have your right to have your day in court. Basically, the government, whether it be the king or fast forward to right now, the government cannot lock you up and throw you in jail without having to bring you forward to show that they have a just cause for having you there. So I think it's in a very, very important individual right. And I know that there's the Hamilton quote, it's a great writ of liberty and all that kind of stuff. And not to be cheesy, but I think it is.
But, and again, it's so excellent there, but also, it can be suspended. That is, there are these, sure. And that's what I mean. My description of our constitutional arrangement is always about balance. Is we're trying to balance these various interests here, and mm-hmm. Obviously, one is to protect individual liberty. The other, we can call it, right. Order, security, those kind of things, and that. In reading Article 1, Section 9, and then doing some more reading on the background of it, is it really articulates that balance in a fairly interesting way there.
Yeah, you're right. That's because it gives you a clear guidelines. When can it be suspended, right? And we know through what happens, I don't want to fast forward, but we know what happens through the Civil War, at least it's articulated who has that power to suspend it. Right, in times of rebellion or invasion of the public safety may require it. I think it's something like that, right? So yep. it gives you guidelines within the document when it can be suspended. So as we know, and students listening to this, no right is absolute. Every right has limits. No right is unlimited, right? Correct. So habeas is limited as well. And we'll probably get into that when we discuss the last bullet.
Yeah, and Dr. Williams, kind of, someone from an international perspective, I was thinking about this because in many ways, and we've all been through this, talking to kids for years about these constitutional questions and things, and habeas corpus tends to get overlooked an awful lot. And like I said, through some of the reading I was doing this week, it came to me that that it's a legitimate statement to say that or the suspension clause or habeas corpus is the single it is maybe the single clause that most distinguishes a free society from an authoritarian society. Would you agree with that, Professor Williams?
Yeah, I would. And preparing for the talk tonight, in law school I took 2 different full courses on habeas corpus, and I've forgotten much of what I learned. But in reviewing, it's foundational for limited government. And I would to kind of echo back what you said, David. It's maybe a necessary but not sufficient if you're going to have a liberal democracy. If you're living in a country where you can get locked up, and as Chris said in the Latin, show me the body, and there can be no process, no procedure for the state to show their case, then you are not living in anything close to democracy. So I think it needs to be, for our students thinking, a foundational principle for any sort of democratic society. Yeah.
And so, and I'm wondering, and to the students, I think I think a good way to express this importance is to talk about or give references to areas of the world that where they aren't protected in this sense. And so, Professor Williams, where would you go in the world and say, see, here's a perfect example? I'm assuming China does not have a suspension clause. I'm assuming Russia doesn't. Does South Africa?
Well, they do now, but this is what they do now in their new dispensation. But this is where we've raised this before about what's in the text may be different than what's actually enforced. So I would say for most human beings right now living on planet Earth, the right or the ability to be taken to a fair court and shown whether the state has a right to hold you under law, it's a minority of human beings right now in the world who have that protection. Even if they're living in places that we would say have a constitutional democracy or have a constitution, because in a lot of ways it's not enforced. So yeah, China comes to mind, Zimbabwe comes to mind, Russia comes to mind. These are all places where people can be locked up and never have any sort of crime, legally kind of held against them.
I'm curious, is Myanmar, would that be one in the group too?
Sure, Myanmar now, usually when you declare martial law, as part of declaring martial law, you are declaring the right of the military to hold people because they think the people are dangerous, right? So right now, Myanmar is under a state of martial law, and I haven't looked into the details, but I'm 99.9% sure that no one has the right of habeas corpus right now in Myanmar.
Mr. Kavanaugh, yeah.
Yeah, just a quick question, Mike, a follow-up. So what humans are not living on planet Earth? So you said that humans on planet Earth. I just was curious if there's some people someplace else that I'm not sure about.
That's a Unit 7 question that I'm not sure if we're going to get into with the 4Bs.
But running out of time.
Yeah, it's all part of the new space initiative.
Space Force.
Well, Professor Kavanaugh is on his game today there. So, Professor Moore, kind of give us some historical context as far as how this comes to be in the American states in the 18th century. There, I think it. Go ahead.
Yeah, I guess I'm going to serve to kind of curb our enthusiasm a little bit here about habeas. But it's got a sordid, squishy past. It wasn't in the American colonial context. All the colonials insisted when they came over that they carried with them all the rights of Englishmen. And what scholars generally have said is that meant to a colonial, they had all the rights of Englishmen. Now, the problem is that habeas corpus is until 1679. So a lot of these statements about having rights of Englishmen that they made were pre-1679 with the passage of the Habeas Corpus Act. So the question is, and it was a concept that was around pre-Magna Carta. I mean, some folks go back to Roman times that it kind of existed there as an idea. So whether it was a part of their common law understanding or not is kind of it's a dubious claim to say it's in their head specifically in early colonial. Now after 1701, Queen Anne actually made the statement that it applied in all the plantations. So at that point, then you could maybe say that it does exist. But again, so it has a checkered, and it was repealed too many times in colonial America as well. So it's not a slam dunk that this is the great. And by the way, our Constitution says privilege. Which seems to me, if we're going to be textualists here a little bit, we have to think about what that means rather than a right. But also, I'd also suggest that the huge exception clause, as public safety may require, well, that's a huge exception.
So
I don't know that lends any clarity to when you can invoke it. So it has a checkered. I'm sorry, go ahead.
It seems to me you're kind of disagreeing with Professor Kavanaugh here, who seemed to say a few minutes ago that it provide great clarity, all right, on when it could be suspended. You're saying
all I'm saying is the colonial period, no.
Fuzzy there, and maybe
in colonial period, no.
Okay. And I find that fascinating because it seems to go, and when we talked about the revolutionary period, it seems to go to the core of this, of this question of, did they have any rights? Did they have any rights of Englishmen? And I was reading something that, they were relying on common law, yet statutorily, there was no statute that granted them this protection. Is that correct?
In the colonies, that's correct. Now later on, their colonies would make habeas corpus statutes, which lends, I think, to the question of is it a right if it's statutorily based? And we might be splitting here. I mean, that's kind of a political science question, but I think it's a relevant question. Is it a right if it's based in a statute? Which is a dilemma for the common law tradition, I think.
Mr. Kavanaugh, you look like you had some responses there.
A couple things here. I would go back to the petitioner right of 1628, and I mentioned this before we came on, the 5 Knights case. For the students, if you want to go back, look up Sir Edward Coke. It looks like it's spelled Coke, C-O-K-E. But look up the 5 Knights case, and it's about Charles being able to collect taxes and whatnot. But because that's going to roll over into the document that's quoted in the question. But that's early on. And certainly that you can go back to Magna Carta to take a look at that as well in terms of habeas. So it goes back earlier. And I know, Tim, you're right about the word privilege, but were you on the bench in the 1870s in the slaughterhouse cases? Because correct me if I'm wrong here, but didn't we colonists believe we have the privileges of English citizenship? Wasn't it the idea of privileges and immunities? That clause actually that's not new in the 14th Amendment. That goes way back, doesn't it? And so the idea of that privilege, I'm not going to say it equates to rights, but is that similar? Mike, you want to jump in here? I'm sorry. No.
Same question. I'm curious, Tim, to get your reflection on the use of the word privilege instead of right, because we know in the Bill of Rights, there's the use of word right is there. So that's what I'm asking.
Yeah, what the framers of the 14th meant, I'm not going to presume to know much there. I'll take your word for that, Chris. But I do think on the 14th, it also says and immunities. So if I was just at a philosophical level making a distinction between privileges and immunities, I would say immunities may be the better word to find rights, just textually. Because you're immune from government action, which seems to me to be very consistent with the idea of
certainly. I think immunity would apply with habeas. Right. Yeah, I agree with that. But my question,
Yeah.
since is honest question, Tim, is that, I mean, I know that I've seen the idea, the concept of privileges and immunities in English law, and
Yes.
it's borrowed
Yes.
from that, right?
Yeah, and it's all my point is for American students, when they use that word right, it's not the concept that comes out of British common law that's statute based. I mean, it's also interesting that the writ of habeas corpus was tethered also to the abolition of the Star Chamber, which originally was a court to beat up your religious dissenters in the realm. So, and of course, you know, if you jail your Catholic enemies or your Protestant enemies, if you're Charles.
Calendar.
So they saw the writ also tethered with the ability to avoid being locked in the Tower of London forever. So I guess I would caution students to see this in American rights framework because of the statutory common law tradition of this, and also consider that it may be that the Star Chamber abolition may be just as important as the writ abolition or the Habeas Corpus Act in '79.
Yeah, I definitely encourage students to look up the history of the Star Chamber.
Tim, I'm sorry if this is jumping us way ahead, Dave. So you can tell me, we'll deal with this later. But I was in this Boumediene case, right? This 2008 case. The Supreme Court makes this statement that the writ is as it was written in 1789. And what I read today is that implied that it was, because there's this discussion of whether it is a actual like a right, or is it just something that Congress can't do? From what I heard you just say, you're disagreeing with the Supreme Court's interpretation of what writ meant at that point, because you're saying it's not, or if I'm going too fast.
Well, no, in fact, that was exactly my next question there. So we're in mind meld here, Professor Williams, but I don't know, because if I understood correctly, Mike, the Marshall Court in the early 1800s, you know, said that it is not an affirmative right. All right, it is only a restriction on government, but not an affirmative right.
Yeah.
And then, so the 2008 decision is in many cases, challenging the first original interpretation, which is closer to the period Tim's talking to, that it's a right. That's my understanding somewhat of the evolution of this. You know,
well, the first Congress in the Judiciary Act, actually, one of the sections in there was them saying that any federal court could issue a writ. So that's when it was kind of positively written statutorily in our tradition. And I think that was 1789.
So I think that's probably a great thing for students to consider, actually. And I hadn't really thought about it till just now. Is it a right or is it a restriction? So do I have a right to habeas corpus, or can the government not restrict?
Right.
Yeah. I mean,
I mean, in the 1600s, as we all know, I mean, there's tremendous wrestling matches between the Crown and the Parliament. And I mean, the writ itself, like in the 1400s, was used for lower courts against the higher courts of the Chancery, the King's Bench. And then like 100 years later, the king was using it as a restriction on lower courts. So it always existed in a political context, and it was a volleyball. And so that's why I would see it as a procedural restriction, much more so than just an absolute right.
So then, I know you hate presentism, Tim.
No, you talk to Chris on Boumediene, because he's the guy on that.
But I mean, maybe Attorney General Gonzalez at the time, right, had argued that it wasn't a right. It was just something Congress could not restrict, because he wanted the Bush administration to be able to suspend it, right? And Congress, right? I read the Boumediene decision as saying, no, it's something more than a restriction.
Mm-hmm.
So I guess, are we all on the same page, Dave? You're saying the Marshall Court said it was a restriction, and you're saying the Boumediene case is saying, no, Marshall, you were wrong. You misinterpreted, even though you were there for the, right? That's kind of where we're at. Okay.
That's my understanding there. And again, partly to that historical development, and Tim, you talking about, a tennis match or a ping pong kind of thing. It is fascinating, historically, if we look at some larger themes, that habeas corpus has been used at one time or at various times to try to consolidate central power, higher courts trying to get power away from lower courts.
Yep.
But at other times, it's been used to try to decentralize the crown. If we look at the Puritans and the opposition in Parliament in the 17th century. And I found that really fascinating, as how this one tool has been used on both sides of the coin of centralization versus decentralization.
And one more thing, and then I'll shut up. But it also came up in ratification. Our good friend Luther Martin, in the Maryland Ratification Convention, raised that specific issue, Dave, that this could be the national government's power grab over state power, because the national government could look at whatever's going on in states, define it as insurrection, define it as treason, define it in those terms, and they could suspend it and punish local citizens that couldn't avail themselves to the statutes within the states that guaranteed their writ of habeas corpus. So Luther Martin saw the federalism danger in the national concept. Now, honestly, on the scheme of the whole ratification, there isn't a lot on habeas, but it does appear in Maryland and a little bit in Massachusetts, where they raise that federalism issue, to your point, David, where it's a higher courts, lower court wrestling match.
So is that just because Luther Martin is a crank? Because my understanding is, if this is one of the issues or clauses that there was very little debate.
No,
correct. Both in Philadelphia and in ratification. It's one of those consensus items where there wasn't. Yeah, Massachusetts, I read about, there was some stuff going on. So
I think most of it in the convention was how long it should be, a year or less, some of that, but yeah, there wasn't much in the debates, but to answer your question, yes, Luther Martin was a crank, in addition to other issues he had, but you could always count on him to raise the federalism argument.
And can I just really punctuate that for the students right now? Because the way we started,
yes, Luther Martin was a crank.
Yeah, he was a crank. But I mean, there is this, the way we started this with about it being a right, it being foundational. Yes, I still stand by those words, but as with almost everything in our discussions and everything you're learning, God, it comes back to federalism. It's like so much of the thinking around the writing of the Constitution, the ratification, isn't about the rights that individuals have as much as the rights that states should have as entities.
Powers, not rights. Powers.
Sorry, powers. But I just think that really exemplifies how even with this, it comes back to an issue of everyone's worried about what the big nasty federal government's going to do, and they're pretty confident their state governments are going to be pretty just or okay, or they can control them. So,
and I still stand by, your point and as well, Mike, and the significance of this, and that's, but your point here is well taken, and it's been a consistent theme, and it's probably why we all love studying this stuff, is because most of it isn't written in concrete. It's not the 10 Commandments. It's squishy in a lot of ways, in the famous phrase of Professor Moore. So even with something that seems as simple as the Great Writ, it's a little bit more complex, especially as it's played out. Now, my understanding is that it's been, I don't want to say implemented or issued 4 times in American history. And I'd like to just quickly do a check-in on those 4 times. And the first one Chris had mentioned, and that is the Lincoln and the suspension of the writ in the Civil War. And it's kind of common understanding that Lincoln was in violation. All right. But I was reading today, and I can't remember if it was a Columbia law or some Texas law. I can't remember which one it was. But if you look at Article 1, Section 9, it doesn't necessarily say who. It doesn't say who gets to suspend there. And for my understanding, Tim, in the ratification, there was discussion about who would be able to suspend that. So was Lincoln really in violation of the Constitution? If we're going to be, literalists, it doesn't say, he shall not be suspended, but it doesn't say suspended by who there. So was one, do you think Lincoln was justified? And two, do you think that this was a violation of the Constitution as you understand it? Anyone who wants to jump on that.
I'll go no and no.
If you could elaborate just a little bit.
No. I think, given the fact that it was a volleyball match between Parliament and the Crown as to who could use it and when, to me means that I don't know. I know it appears in Article 1, but there's stuff in Article 1 that apply to other branches too. But the fact that historically it was a contested thing between a legislature and a monarch. There's enough precedent for both of those entities to suspend it. Now, that's British. We're Americans. Does everything change? We have enumerated. This gets to the enumeration issue. If it's enumerated and where it's enumerated, I understand that logic. But historically, I don't know that it's centered in one particular entity. And I to the second question, I don't know what Civil War constitutes, but it seems to me public safety might, that might cover the Civil War.
So even though Lincoln used it.
Mike is ready to have a meltdown.
Yeah. So I just want to be clear that I understand you. You believe that whether or not Lincoln had the power, it still was used legitimately because it is a situation of war and it necessitates the protection of public safety.
That's my story, and I'm going to stick to it. Yes.
Okay.
Have at it, Mike. Have at it.
Yeah.
No, I'm just surprised, Tim. I wasn't expecting you to make that argument. Because I know Article 1 speaks about other powers, but it's mostly about the legislative branch, and the framers could have just as easily said in Article 2 the president has the power to suspend the writ of habeas corpus. And the whole Civil War political context to me, Lincoln says I'm going to suspend it, right? And then the Merriman decision says, you can't do that, Mr. President. Congress comes in and says, we'll suspend it for you, Mr. President. But Merriman never gets out of jail. He never gets a day in court.
Yeah.
So, my reading of the context of the Constitution is that it is for Congress to suspend. But I'm just surprised with your argument.
I know you're right, Mike. And worse, to beat my own argument up, Lincoln, he demonstrates he knows he's sinned because he goes to the legislature and asks forgiveness. Right. So there's another one for you to use.
Well, and I don't know for what this is worth though, but it in Philadelphia, the committee of style, they had it initially in Article 6.
Yeah.
And also, I think that does bring into question whether they themselves were really focusing on that Congress only can suspend it, not anybody else, given the discussions they had about even where to put it in the Constitution. Mr. Kavanaugh, thoughts?
Oh, well, gosh, I got a lot of them.
I told you I'd be the voice of unreason tonight.
I appreciate what you're saying. I'm not sure if I agree, because I went to my handy dandy pocket Constitution to make sure I had this right, and all legislative power herein granted. And I go to Article 2 and it says the executive power shall be vested. So I'm wondering if the intros to those two articles indicate that it truly is a legislative power. And if they intended it to be a generic power, then would they have left it in 6? And, do you think, I don't think the framers would have been comfortable with saying, oh, it's a legislative or executive power and give that power to the executive. And to your point about Lincoln going to the Congress and students, he makes this it's called his all laws but one speech. You should look that up. It's really good.
Yeah.
Because you can tie it back to John Locke's retroactive authorization. Locke talked about the Locke and the row houses, right? Real quickly, John Locke talked about if you came upon these row houses, all these homes that are built close together everywhere, and you saw a row house on fire, and you knew that all the row houses would burn up. So you tear down 1 or 2 to stop the fire from spreading. Did you break the law? Yes, you did. Why'd you do it? Because it was an emergency. So you go to the local magistrate and said, I did this, now make it right. I did this because there was a problem, now make it right. That's the same thing Lincoln does when he goes to Congress and said, yeah, I did this. I did a bunch of stuff. You guys weren't in session, now make it right. And Congress does make it right. They do allow him to do that. So that's how he gets around Merriman. Of course, students remember that Taney in that decision was writing circuit. That was not a Supreme Court opinion. That was a circuit court opinion. And Lincoln just kind of blew him off. So I think those are things to remember. But I do think that all legislative power herein granted, that might be, I don't know if that's key or not, to look at the beginning of Article 1 to see if that is a legislative power. I believe that it is a legislative power because I don't think the framers will be comfortable giving that power to the executive. Because going back to, Tim, your other point, because there's a pretty big door to drive, a pretty big, garage door to drive through when you talk about the public safety may require it. So holy cow, are you guys comfortable, or anybody comfortable with the president saying, oh, well, the public safety requires it, so I got to lock some people up without trial?
Yep.
This is something interesting because there's the political principles and philosophy, and then there's just like the political practice. And I'm thinking that this same thing happened, 10, 15 years ago, right? Where President Bush did some things by directive of the president. The Supreme Court said, nope, you can't do that. Congress only can do that. And then Congress did it. And the Supreme Court said, nope, you still can't do it, Congress. But, so it's still this like the practice of this particular clause in the Constitution, whatever the framers intended, it seems like it's turned into, politically speaking, people recognize it's Congress's authority to suspend it. And they play the game of pushing power. But even President Bush went to Congress and says, pass me a Military Commissions Act so I can do this, of which then the Supreme Court said a part of that was unconstitutional. But it seems to me the practice of this has kind of given it meaning in a way that's really interesting, no matter what sort of the original intentions were.
Well, I think if you look at the terror cases for students, I look at Hamdi, I look at Hamdan, and then we mentioned Boumediene earlier. And if you look at the interplay, because it really is fascinating, because the president takes an action, the court slaps him down. You get Justice O'Connor's famous line that the war power is not a blank check for the power of the president kind of idea. And you see this interplay. So the court kind of gives the president a roadmap of what you can do. And then he goes to Congress, as Mike said, and the Congress responds. And then the court says, okay, you got part of it right. Now come back and take a look at this. And so you do see the interplay between the three branches. And the court kind of gives Congress and President Bush at the time a roadmap on how to move forward to expand executive power in the war on terror. But those cases, the terror cases, Hamdan, Hamdi, and Boumediene, Hamdi, Hamdan, and Boumediene in that order, I would definitely look at those, because it's interesting for me to think about those cases. As Tim knows, I did some work on those cases a couple years back, and holy cow, those opinions are divided. They're messy. They're difficult to get through. Because you've got people joining in part and not in other parts. It's really difficult. So you can see the court was struggling this with as well. And to me, it's interesting to think about the Five Knights case in 1628. You go back to 1628, and we're still dealing with this same right or privilege in the terror cases. And it's fascinating to me that, as I think Mike or Dave said earlier, that we're still wrestling with this, right, in this present day.
So the second reference is not that far removed from Lincoln, is South Carolina and the Klan and Congress. And I found this fascinating. They targeted like 10 counties in South Carolina. which again, I found fascinating that this thing can be so narrowly tailored. I mean, Lincoln's suspension was that Maryland?
Well, before we move on from Lincoln, we should mention Milligan, ex parte Milligan as well, right? I mean, to me, what's important about Milligan, Lambda Milligan belonged to a group called the Sons of Liberty in Indiana. Go figure, right? And if I know we're familiar with the decision, the Supreme Court said when the civilian courts are open, that's where he should be tried, not in a military court. And I think for students, what's fascinating about that decision, it was issued by Justice Davis. Now Lincoln was dead by this time. He was already been assassinated by the time the ruling came out. But Justice Davis was Lincoln's campaign manager for his second campaign. And so he's ruling against Lincoln, though Lincoln is dead. And there's a great line in there that said, not every president will be a Washington or a Lincoln. Wicked men may occupy this office. Some great language in his decision to take a look at that. But Lincoln, I mean, talking about kicking a guy when he's down, he loses at Milligan. So
I don't know why I found that. I don't know why I found that funny, but there. Well, again, we come back to federalism. So in essence, Congress can suspend the writ theoretically in Waukesha, Milwaukee, and that's the only place. Is that my understanding?
If you get a bunch of disgruntled Brewers fans.
Certainly.
Well,
certainly.
And
are there any other kind of Brewers fans other than disgruntled?
Touche.
So the fear of federal courts and Congress intruding on not only states but municipalities as well seems real here with the suspension power, that they can target it that narrowly and argue that qualifies as a rebellion, that threatens. Is it, when they mean public safety, are they talking just help me out, what do they mean by public safety? Or I'm thinking about order and government, the stability of government and the return to the state of nature, kind of public safety.
January 6th.
Yeah, there was a threat.
The KKK in South Carolina in 1871, legitimately an open rebellion against the United States of America in the sense that they're still trying to overthrow it.
Yeah. Well, I mean, I can't help but think of a lot of our thinking about habeas. It seems to me comes out of the lack of the writ to American rebels in the Revolution. I mean, a lot of them were taken. Some of I think Lawrence actually wound up in Tower, London, and they all wanted to make the argument as British citizens they had access to a writ. And in various states and various times and various locations, the writ was not there in the middle of that American Civil War. So I think there's a great sensitivity at the founding period to this lack of it in the context of that war. So I think context matters, but I think it's a particularly sensitive issue for the founding generation, and probably why many of the state constitutions do write it into their constitutions immediately during or after the American Revolution. But that's, to your point, David, is it in the context of wartime and sorting this out. And even, Washington, I mean, there was no writ to suspend as an American, but I mean, as a military commander, he did some things that we would consider, well, that's not anywhere close to due process for some of his own troops and fellow Americans. So the founding and the revolution is particularly, I think, the Rubicon in this becoming more of a rights concept for Americans than it was before.
So the third reference is, and again, I found this fascinating because I didn't, a lot of this I didn't know until is in the Philippines during the Filipino insurrection.
Yeah. It
was suspended. Now, is that by, again, help me out, is it the prize cases, I mean, that the Constitution doesn't stop at our shores kind of thing? Is it that are the Philippines a protectorate of ours at the time? I mean, how does this apply in the Philippines?
Well, post-war Spanish-American War, when the Filipinos help us liberate their island, and then we decide, oh yeah, by the way, we're not leaving, right? I can see the leader's name. I'm gonna butcher it. So
Emiliano Aguinaldo.
Aguinaldo, yes. Who is our ally, and then we say, oh, we're not leaving. He says, oh, wait a minute, I thought you were liberating us, right? And so they were, and I had to, gosh dang, I was just looking at this. Were they a protectorate? They maybe we considered them a protectorate at the time.
I think so.
I think it was after, soon after, but I'm don't hold me to that.
Yeah. So
yeah,
so in the Filipino rebellion against us, the idea of, it wasn't against the Spanish, it was against us because we weren't leaving. We suspended, which gave the military a great, if students have taken a look at what we did in the Philippines post Spanish American War, it was really, really ugly.
Can I just say, just to remind the students of what kind of power this is? When we talk about this, it's putting someone in prison and never letting them have a day in court, never letting them be heard what's been tried against them, literally putting them in a tower and letting them die there. I know this is a sub question in what we're talking about. That is such a drastic power. And I'm of two minds against it, because after Civil War, Reconstruction, I want I want the federal government to send a message. KKK, you're no longer running things. And we'll suspend the writ as a deterrence. We're just going to show you, right? You 10 may do it, but the next 10 won't, because we're going to put you in prison. You're never going to see the light of day. That's going to stop this. Now, fast forward to Philippines, when we're the colonial power doing it, man, it's not what any government should be doing. It goes so much against the fabric of human dignity. There are other ways to put down rebellions. There are other ways to get the safety that you want, other than to lock people up and never give them the day in court. So
you're okay with it some places and other places?
No, I'm saying a part of me is okay with it after Reconstruction, but when it comes down to it, no, I'm not okay with it, because there's other ways. You arrest those folks for violating the law, you let them have their day in court, and then you put them away. I mean, this idea of locking people away and never give them the day in court, it's too drastic. It's too drastic for me. My voice just broke, like Peter Brady. Now that's a 4B's reference right there for you. Peter Brady, students, go look it up. Peter Brady, Brady Bunch, when his voice changes.
Marsha.
Oh man, it's such a great episode.
Wow, I never thought I'd hear the word "great" associated with the Brady Bunch there, but there we are. So the fourth reference is.
Well, I'm going to solve Mike's dilemma on this. All right,
please.
All I'm saying, and I'm probably a broken record on this. All I'm saying is I don't believe. I mean, Chris said this earlier. No right's absolute. Well, I don't even think this is a right. So if I lessen it from being a right, then there's a great opportunity for a zone of gray in the penumbras of law. Now I'm scared to death of the implications too, Mike. I understand that, but all I'm saying is the context of this is it's a statutory privilege. It has a contested history. We've converted it into it being a right, which that's a different discussion if it indeed is a right, and maybe it is, and then you're correct. But historically, I don't know we can get there. And even in the text of the Constitution, I'm not sure we can get to this absolutist approach on this.
So, but I guess, and I hear what you're saying. I think you're making a great point, and I have to think about it. But if it's not a right, then we're kind of, I almost said a bad word. we're kind of in trouble. If
I
it's
know.
not-
I don't like the slippery slope on that either.
So if it's really a restriction on government power and not the right for me to have my day in court, so I'm not guaranteed my day in court because the writ of habeas corpus is not a right; it is restriction. That makes me just nervous as all get out.
Sure.
Well, so the fourth,
I hear you, and I'm afraid of the slippery slope too. But I'm stuck with the history and the text of the Constitution.
If you just believe in natural law, this would all go away.
Yeah. Yeah.
thank you, Justice Thomas. I appreciate that. So the fourth reference, and again, I found this interesting. It was really never implemented, but was Hawaii after Pearl Harbor. My understanding is they never really implemented this. You know, they declared martial law, which ipso facto, you know, suspends the writ of habeas corpus there. Yeah, they did detain individuals, but my understanding is they didn't throw away the key kind of thing. But off of that, here's my question, and I wonder now, you know, after the fact, years after the fact, is, you know, I would tell students that, you know, that 9066 was a suspension of the writ. But in my reading, you know, over this past week, that's not, at least from the legal community, that's not what they're saying. That Executive Order 9066 was not a suspension of the writ. They did do it in Hawaii, but they did not do it on the mainland. You know, yet they declared martial law in California, Oregon, and Washington, right? Is that correct?
Didn't Governor Warren do that in California? I thought.
Yeah.
I don't know. I don't know about the rest of the West Coast.
Well, okay, so there's kind of a sub question. Does a governor have a power to suspend the writ? Mike, you're shaking your head, yes?
I mean, my understanding is that state constitutions can give governors that right, that power, sorry. And I don't know what the status is in the 50 states right now, but I would assume most have that. That's just my assumption. Students should.
That backs up Tim in saying that the president can do it. Because if governors can do it, why can't the president do it?
Yeah. Well, I mean, at the founding, that was the case. Now, I don't know what the status is now, right? I don't know.
Well, looking at the dictionary definition of the writ where we started off, do you guys consider Executive Order 9066 a suspension of the writ of habeas corpus?
I don't think so. I'm going to jump quickly here without thinking, as I usually do. I'm going to say no in the fact that nobody was actually, well, gosh dang it.
Keep going with that. Keep going with that.
Well,
nobody was jailed, right?
Yeah, well, but I thought that, but then, you know, if you're put in a camp, right, we'll put in an internment camp. That's the second time I've used air quotes tonight, right? If you put in an internment camp, aren't you really locked up? And if you look at the cases like Korematsu and Hirabayashi, if you look at those cases that are around those, I mean,
the fact that they had those cases, does that speak to the fact that it wasn't a suspension of the writ?
Yeah, because there were other issues involved in it.
I thought they argued due process more than writ.
Those weren't habeas cases. So
No, that's what I mean. But like when habeas is suspended, it means you don't get your day in court.
Right.
Right.
I mean, they got their day in court and they lost.
So,
right.
So no habeas. It's not a habeas issue, due process issue.
I disagree. They got a day in court to see if they had a day in court. And the court said you don't get a day in court.
Yeah, that's good.
You get your day in court to say that you don't have a day in court?
Exactly. Right? Isn't that what the court determined? Is that you don't get to challenge this, all right, in either federal, court or state court?
What was the constitutional question in Korematsu and Hirabayashi? What were those questions don't come to mind.
one dealt with the curfew laws in California. And then, and I think that's Hayabashi, is that correct? Gosh.
Yeah, I
Now,
think
all
that's,
this,
yeah, the curfew one.
and then, and he was arrested for violating curfew. Korematsu challenged just the whole internment thing, I thought, there. But like I said, I just, to me, this is a classic, suspension of the writs. They rounded up 110,000 people. They put them in camps, whether you want to call them concentration or prison camps. They did not get, a day in court before that was done. They were also denied their property, in doing so. I mean, and again, in hindsight, we look back and say, yeah, this was an atrocity, but there were also voices at the time going, this is not right. And wasn't Korematsu a 7-2? It was not a unanimous decision.
6-3.
6-3. So there,
Yep.
It would be interesting to read the dissent there. Now,
the dissents in Korematsu.
yeah,
Look up Murphy and Jackson. I mean, their language in those dissents. They're talking about putting, Jackson's, to me, the dissent was great because he was guilty of being who he was in the place he was. And the dissents in Korematsu are beautiful, beautiful. Yeah. I'm checking my constitutional law book here.
And the constitutional question was Fifth Amendment. It wasn't a habeas case.
Right. It wasn't a habeas case.
No.
But should it have been? Or why didn't they file under a habeas standard? I'm wondering, because it seems to be a classic.
But can you, students, you are now witnessing, students, the 4Bs processing stuff as we're live. You can't allege habeas unless some authority says we're suspending habeas.
Right.
I mean, at that moment, FDR or Congress, they didn't suspend habeas. They just said, we're passing this military directive.
Yeah.
Which is even scarier.
Yeah.
Right.
Right. Yes.
Thank you. So I want to recognize that we've gone from, Professor Kavanaugh's, the directness and simplicity of Article 1, Section 9 to now, this really scary clause in the Constitution that gives, in many ways, the federal government runaway power if they wish to use it, just by labeling something an invasion or a rebellion.
Yeah,
I find that a fascinating evolution of our.
Well, what's even scarier is that they didn't even, to me, they're not even relying upon the Constitution. It's just, it's wartime, and it's time, like Chris has said, the Constitution is not a suicide pact, right? To quote, was that Frankfurter? Am I remembering that? Jackson, sorry. Yep. So.
Yeah, well, it goes back to Hobbes. What do we fear? We fear the violent death of another. So we're willing to give the government power.
Yeah.
And for students, this is what I was talking about, that language. This is Justice Murphy. I dissent in the Korematsu, excuse me. I dissent, therefore, from this legalization of racism. Racial discrimination in any form and in any degree has no justifiable part whatsoever in our democratic way of life. And then if you go to Jackson's part of his dissent, now, if any fundamental assumption underlies our system is that a guilt is personal and not inheritable. And he goes on to talk about the corruption of blood clause for treason. And so it's beautiful language in terms of Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born and where all his life he has lived.
Yeah. And just to get even more into the weeds for the students, the Supreme Court in this decision, I'm not sure if it was the first time, it was one of the first times they used compelling state interest. They used strict scrutiny in this case, and they still found that it overcame strict scrutiny. Like the state had a compelling state interest to do this, even though race was involved. So just to amplify your point.
Let me ask this, is the in the suspension clause of the Constitution when it says as public safety may require it? Isn't that another way of saying compelling state interest? I mean, I don't know the answer to that, but it does seem like there's an out clause.
It's a big hole, isn't it?
Yeah, I think it is. Exactly. I think it is.
I see.
And for students, one more fun thing is we mentioned Governor Earl Warren, who is all for this. This is the same Earl Warren that becomes Chief Justice of the Supreme Court. And in a few years, he's like, wow, I found some rights over here. I found some rights over here. So it's,
yeah, and if you've read biographies, he does have numerous epiphanies between the time he's governor and the time he's chief. He definitely does evolve. You know, our time frame is getting tight, and there's a couple of topics I still want to address, and both of them kind of rely on Professor Williams. So going to the third bullet, this is one of those questions that I found somewhat inane there, and I'm just wondering if you agree with me. Under what circumstance might habeas corpus place it seems to me for the last half an hour, we've been talking about how this is a potential runaway power and very much a potential for abuse of power. How in any way, shape, or form could it be an unreasonable burden on the government? Can somebody explain that to me?
Yes,
go ahead.
I would tell the students to go look at death penalty cases starting in the 1990s, where death row inmates are filing habeas writs, and the court starts to stop that. They start to put restrictions on that because they consider that an overreach. And so the idea that these habeas, and I don't know, I don't have a law degree, so I don't know that I can explain it, but they start to put restrictions on.
Well, yeah, it's called EDPA is the acronym, or the it's 1996. It's the Anti-Terrorism and Effective Death Penalty Act, and that's where I want to go next. And just to point out to students, when it talks about the evolution, for hundreds of years, even pre-colonial times, throughout the 19th and early 20th century, that we thought of the writ primarily as used by those imprisoned without judicial process. Today, when you talk about the writ, it's used by those who are in prison already, having had a judicial process, and they use the writ to challenge the legality of that process and appeals process. And what EDPA does, and again, I'm glad you brought it up, Chris, because I questioned the reasonability here, or the idea that it was unreasonable, because the flip side of that coin, and to me, what has happened is that we've really undermined due process for those convicted of capital crimes to be able to appeal, because the law allows them one appeal, all right, through the federal court system. Now they can try again, but they got to get, they've got to have such a compelling reason to try again, and it flies in the face of the evidence, of how many capital cases have had major errors in the process and need to be reviewed in that sense. But you are absolutely right that might be the one exception to mine, of it being unreasonable burden on government, which is what Congress and what the court affirmed, is these guys on death row were filing, writ after writ after writ, and delaying the process. I
would say, okay, to get to the first question that you asked. Okay. Martin Luther King said, we're going to take on unjust laws, arrest us, give us our day in court. We're going to keep kind of like pushing the system, right? So the question is, can I imagine a time when the writ would be unreasonable for government? Imagine January 6th, 2021 happening simultaneously in 51 places in the country, the DC capital and 50 state capitals. And the federal government is responding to that. Would it be an unreasonable burden for them to bring all of those and have a hearing?
No.
And if your answer is no, then that to me is the ultimate kind of scenario of like, if we want to give the government a pass on human dignity, like when the republic is at threat from violent sort of insurrection, that would be the only reason it would be unreasonable. And if we even at that point say, no, it's not unreasonable, arrest them, they have to be violating something, property laws, right? Possession laws, there's something, let's try them. Then yeah, to that question, I would say, then I can't think of a way it's unreasonable to the specific question the students were asked. And then David, to your larger point, all this talk about Lincoln and FDR, you're absolutely right. The vast majority of habeas corpus and the 2 courses I took in law school were all about people being prosecuted and sentenced in state courts. And they're filing these petitions, students, they're writing these from their jail cells. Like, this is what brought home to me in law school. They are writing on a notepad. The evidence brought against me in this state court in South Carolina was illegitimate. I'm innocent, but the state court is biased. Please hear my case. Federal court, hear my case. The state is biased against me because I am blue-eyed, black-skinned, blonde hair, whatever, right? And David's right that since 1996, and that was passed after the bombings of Oklahoma City, right? It was a response to terrorism. We have limited the ability for those in state courts to appeal their decisions to federal courts, which again, to me, comes back to federalism. It's like, this was a big win for Republicans or those who believed in state sovereignty in 1996, right? It was like, give deference back to the states,
right?
Because, and I'm sorry, I'm saying a lot here, but it's like all these different themes coming back together. This is not about wartime. This is about someone right now sitting in some jail cell in Texas who's not guilty and wants a different 3 judges to hear his case who aren't from Texas. And he's being denied that, or she's being denied that, because right now, David's absolutely right. You get one chance, and when that chance is gone, you're stuck. So
Well,
that's what's going on.
And the point I was making earlier about death row inmates, this is pre that act, David, that you mentioned. These are pre that. And so students, I'm going to throw out some cases for you to look at. And that is Teague versus Lane, Teague versus Lane, 1989. Then you want to take a look at Butler versus McKellar in 1990. And then looks like Saffle, Saffle versus Parks in 1990. There's a series of cases there where the court was limited. Is exactly what Mike was saying. Folks in state courts, people that were charged at the state level, were appealing to the federal level to exactly what Mike was alluding to there. So this is pre-Boston Marathon bombing and pre-terrorist law. These are people that are languishing in state courts, believing that they've been railroaded, and the court started limiting those appeals.
Right, and I
habeas appeals.
Yeah, and I read a study from Columbia Law. It's like 47% of state capital cases, there are errors in the process. There's violations of due process from along the pathway there. And again, going back to one of our original questions, if the writ is a right, to me, this is the fundamental purpose of Article 1, Section 9, to have federal coverage over the states, and in that situation that, states, violate due process. And EDPA seems to me to undermine the very core purpose of the writ of habeas corpus in our system of government. So I want to give each of you, a chance if you have one last insight, comment, thought about habeas corpus as we begin to wrap up. Now is the time to share. What do you think? What would you advise to students on this question? Mr. Moore?
I for about 25 minutes now, my eyes have glassed over since we're into an area of law I have very little awareness of. So I will defer to my colleagues who are much more insightful on this than I am.
Well, I would say that's bunk, but that's the technical term. And I was, for the students, I would say draw that line from England that we mentioned earlier, and draw that line all the way up to now, and think about and I think, Tim's point is well made, and it's a great point to wrestle with in your units of study. Is it a right or is it a restriction? Right. I think that time, is it my right? Is it your right? Or is it a restriction on government power? And then draw that line through history and connect those dots, because that's a long line to draw.
Professor Williams.
Yeah, I have a few thoughts. Exactly. I think, Tim, you're being so humble, but I think you gave the students the major thing to think about. Is this a right or not? And I think that should be part of whatever they prepare. Chris, I think you've shown in this episode why you're known as the person who explains things after the rest of us kind of go off.
All that means is my brain is stuck at age 16.
No, it does not. No, teaching is an art and a skill, and I think you've demonstrated that. And then finally, I would just say to the students, man, this is one of the most complicated phrases. and like I said, I took two whole law classes on this, and I still don't think I completely get it. But if you are passionate about being involved in a career where you're giving voice to people who think that they haven't had fair process, then there are careers to be made where what you do is you talk about the writ of habeas corpus every day of your life, and you're writing about it, and you're taking people's stories and trying to get them a day in court. It's a real thing for a lot of people right now in the country. So I would just encourage you to think about what you can do with this question in terms of your career, what you do as a vocation. Yeah.
All right. So that brings this session to an end, students and teachers. We hope that you gained some insights. In our next session, we're going to be looking at American foreign policy, and we're hoping to have our good friend Liza Prendergast back with us to talk about the American Constitution, American foreign policy. Until that time, have a good week, and we'll see you at same bad time, same bad place. Peace, love, yogurt, tacos.